Hi everyone. On the 7th of October 2020, the Irish Government enacted Statutory Instrument 413 of 2020, the purpose of which is to restrict the rights of citizens to travel freely within and outside of the state, to compel certain businesses to close unless they can offer a takeaway service, and to endeavour to restrict human rights such as the right to protest, the right to attend a marriage ceremony, the right to attend a funeral, and to gather with family and friends. Once again, I start this video by confirming that the initial lockdown period was advertised as lasting only 4 days from the 8th of April to the 12th of April. Many of us knew at that time that if we relinquished our freedoms with so little thought, the consequences would be catastrophic. The Irish government's implementation of the current lockdown has only been possible due to the blasé attitude of many to freedom. Ben Franklin said that those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety. Let's now take a look at the statutory instrument. The regulation is split over 13 sections as follows. Section 1 confirms that the regulation comes into operation on the 7th of October 2020. Section 2 confirms that the regulation shall remain in operation until the 28th of October 2020. But remember once again that this date will likely be extended. Section 3 revokes Statutory Instrument 352 of 2020. This was the statutory instrument that was used to implement the Level 3 lockdown measures in Dublin and Donegal. Section 4 is the definition section and includes definitions for phrases like who is an applicable person, what is a relevant event, what is a substantial meal, and so on. Section 5 deals with restrictions of movements of applicable persons. An applicable person being somebody who ordinarily resides at a residence in the state, or if a person is not ordinarily resident in the state, the premises in the state that the person is currently residing at, whether on a temporary or permanent basis. This Section 5 states that an applicable person shall not travel from his or her county of residence to another county or outside of the state without a reasonable excuse. So not only can you not leave the county you ordinarily reside in, you also cannot leave the state unless you have a reasonable excuse. Section 5.2 sets out what is considered a reasonable excuse for the purposes of travel and includes A. For work, B. To perform the services of an office holder, C. Farming, D. Attend school, college or other training facility or to accompany a person to such activity, E. Childcare, F. Medical or dental appointments or to accompany a person to such appointment, G. Attend an essential medical, health or dental appointment or accompany a person to such an appointment, H. Donate blood, I. Seek veterinary assistance, J. Attend to vital family matters. Note that this is a very broad excuse that could facilitate your travel for a multitude of reasons. K. Attend a funeral. L. Fulfill a legal obligation such as attending court. M. To give effect to custody arrangements for children. N. In the case of a priest or a minister of religion to lead worship remotely, minister to the sick or conduct funerals or wedding services. P. To return to a person's place of residence. So this is a new reasonable excuse that was not set out in previous regulations. So presumably this is to allow people who have been travelling outside of the state or within the state but outside of their own county of residence to return home. Q. Where the person is not ordinarily resident in the state, to leave the state. Or to provide emergency assistance, avoid injury or illness or escape of risk or harm. So this means that if your house is being burgled and you've escaped your home but the burglar is chasing you, you can cross over the county line and you're not breaking the law. It's good to know. For assistance, I've included in the description box of this video a link to a form that allows you to select your reason for travel from the list of reasonable excuses mandated by the Irish government. I would suggest that if you intend on travelling outside of your county, that you bring this form with you in order that you have all reasonable excuses to hand at all times. It is important to note that this Section 5 is not noted as being a penal provision. Section 6 deals with restrictions on events in private dwellings and provides that you may not organise an event in your home for social or recreational reasons with more than 6 persons in attendance from more than one household. This excludes the persons who ordinarily reside in the residence. Note again that Section 6 is not noted as being a penal provision. Section 7 deals with restrictions on certain events and funerals and provides that you may only organise a relevant event, with a relevant event being an event held for social, recreational, exercise, cultural, entertainment or community reasons, but excluding events held in private homes, wedding receptions, sporting events or training events. So you may only organise a relevant event if the event is to take place outdoors and with no more than 15 persons in attendance. In relation to funerals, you may only have 25 persons in attendance, excluding the priest. This Section 7 is noted as being a penal provision, meaning that any breach of this section could expose the organisers of such events to a fine of €2,500 and or 6 months in prison. Section 8 deals with wedding receptions and provides that the maximum number of persons that may attend a wedding reception is 25 persons, noting that this 25 number does not apply to private homes. Section 8 is not noted as being a penal provision. Section 9 deals with restrictions on sporting events. I do not propose to go into the detail of this section except to note that this section is not noted as being a penal provision. Section 10 deals with restrictions on training events and provides that training events may be held provided persons attending the event are organised into groups of no more than 15 persons and the groups do not commingle and the training event is held outdoors. Note, this Section 10 is not noted as being a penal provision. Section 11.1 deals with the closure of certain businesses and services and provides that a specified person, so that is the occupier, manager, person in charge or controller of the premises, will not permit members of the public access to a premises where a relevant business or service is carried on. So this Section 11.1 mandates the closure of the following types of businesses: cinemas, theatres or concert halls, museums, art galleries, circuses, nightclubs, bingo halls, private members clubs, ice skating rinks, roller skating rinks, aquariums, indoor leisure facilities including bowling alleys, amusement arcades, dance studios, soft play areas and other indoor children play areas, fun fairs, amusement halls, amusement parks and theme parks, sports stadiums, campuses and sports training facilities, other than insofar as they are available free of charge for informal and recreational use by members of the public. And finally, outlets selling food or beverages. But this excludes outlets selling food or beverages A, on a takeaway basis, B, for consumption in an area which is situated outdoors and which holds no more than 15 persons, C, staff canteens, or D, a hotel insofar as they sell food and beverages for consumption on the premises by residents. So it is this Section 11.1 that has resulted in the closure of all the pubs and restaurants in the country. This Section 11.1 is noted as being a penal provision. So any breach of this section of the regulation would open you up to a fine of up to €2,500 and or 6 months imprisonment. Section 11.3 further provides that a specified person, so this again is the occupier, manager, person in charge or controller of the premises, shall ensure that members of the public are not permitted to access or remain on a relevant premises. And in this case, a relevant premises means an outlet selling food and alcoholic beverages for consumption in an outdoor area or a hotel or similar accommodation and which sells alcohol for consumption on the premises during the relevant period, and this means after 11:30 p.m, except for the purposes of ordering or collecting food or non-alcoholic beverages for consumption off the premises. This section means that outdoor eating and drinking areas and hotel bars and restaurants that serve residents must close at 11:30 p.m. The next section, Section 11.3d, applies only to the County of Dublin, which is rather peculiar. This section states that a specified person, as defined earlier, shall ensure that members of the public are not permitted access to a relevant premises. And in this case, a relevant premises means an outlet selling food and alcoholic beverages for consumption in an outdoor area or a hotel or similar accommodation which sells alcohol for consumption on the premises, unless that member of the public orders and consumes a substantial meal, which we know from the definition section means a meal that is reasonable in all the circumstances to charge €9 in respect of. The next section, which is Section 12, provides that a specified person, as defined earlier, is required to record the following information with regard to those consuming food or alcohol as a resident of a hotel or similar accommodation, or those consuming food or alcohol from an outlet to be consumed in an area situated outdoors. The information to be recorded is the time and date, name and phone number of the lead person where a party of persons are concerned, the time, date, name and phone number of the sole person where a party of one is concerned. In the case of a person located in the county of Dublin, a record of the substantial meal ordered. This information is required to be retained for 28 days and be made available for inspection by An Garda Síochána or the HSE. Note the sections with regard to the gathering and retention of information are noted as being penal provisions. Section 13 deals with data protection and confirms that the collection, processing and retention of personal data referred to in Section 12 is lawful. While I appreciate that most of you have watched this video in order to understand your rights around travel, what I'm about to say next is far more important than the current travel restrictions. You might recall that back in April of this year we looked at the Health Preservation and Protection and Other Emergency Measures in the Public Interest Act 2020. And you might also recall that we discussed the fact that the section of that legislation which has permitted restrictions around travel, including the one discussed today, so this is Part 3 of the Health Preservation Act, has an expiration period that is fast approaching. Under Section 2, Commencement and Operation of the Health Preservation Act, it states that Part 3 shall only continue in operation until the 9th day of November 2020, unless a resolution approving the continuation of Part 3 has been passed by both houses of the Oireachtas. What this means is that we have a window of opportunity inside which we may lobby the government in order that Part 3 of the Health Preservation Act does not continue past the 9th of November. Because if this Part 3 is not passed, then all travel restrictions, all restrictions around the closure of business, all mandatory face mask legislation will expire on that date. Therefore, the next 4 weeks are crucial in reclaiming your rights. I have done my best to present the COVID laws in as impartial a manner as possible. However, I must make an exception on this occasion given the gravity of the measures we will be faced with if the legislation permitting restrictions around our human rights continues past the 9th of November. We are right now teetering on the edge of a complete loss of our fundamental rights. You are the key to reversing the erosion of our freedoms, but you must act now. Thanks for listening.